So we need to talk about a recent 9-0 unanimous decision issued by the Supreme Court involving the Fourth Amendment's protections and when excessive force by law enforcement impacts those rights. The Fifth Circuit has now issued a new ruling, potentially defying that ruling, and this could be heading back to the Supreme Court already. So let's break down what is happening in this critical case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also, double check to make sure YouTube has not unsubscribed you. A lot of people check and they find out that that has happened. I also want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form is an amazing company. Their culture is unmatched. They're pro-freedom, pro-America, and they support the Second Amendment. And also, they have amazing supplements. So, if you know this holiday season, you're trying to get healthier, check them out using my link down below. And if you order using my link and you order something $100 or more, you can get free shipping on that order. And also, they have a money-back guarantee. So if you're not absolutely satisfied, you can get your money back. Now, as I mentioned in the intro in this video, we're going to be discussing a recent 9-0 unanimous decision that was issued by the Supreme Court. This case involves the Fourth Amendment's protections against unreasonable searches and seizures and when law enforcement activities through excessive force can impact those rights. This ruling came in a case called Barnes versus Felix, and this case may already be heading back to Supreme Court for re-review just 6 months after the court issued that 9-0 ruling. That is because the Fifth Circuit has issued a new decision in light of what the Supreme Court already said, and the Fifth Circuit has once again ruled that the officer here in this case and his actions are protected even under the totality of the circumstances approach. And the en banc panel here in the Fifth Circuit also just denied review of this case. The Fifth Circuit has engaged in some very interesting reviews and approaches in this case after the Supreme Court remanded this case back to them to re-review and re-decide the case. And now the plaintiff in this challenge is arguing that the en banc panel probably should have received and taken review of that case, and this likely once again will head to Supreme Court. At least there will be a petition for the Supreme Court to take this issue up once again. Now, the facts surrounding this case are as follows. Essentially, Roberto Felix Jr., a law enforcement officer, pulled over an individual, Ashton Barnes, for suspected toll violations. It was in the Houston area. I believe some cameras picked up some toll violations based on the license plate, and I believe even the vehicle that he was driving was a rental car, so they weren't probably even toll violations directly connected to him. Now, Felix ordered Barnes to exit the vehicle, and Barnes opened the door, acted like he was going to exit, and then tried to, and essentially attempted to drive away and flee. Now, reacting in a split second, the officer decided to jump onto the ledge of the car as the car was driving away. He then fired 2 shots at Barnes as the car was driving away, and both hit him, and unfortunately, they were fatal shots. The vehicle was stopped, but really all this happened within, I believe, a 5-second time span of when he was told to exit the vehicle, when he tried to drive away, and when the officer decided to jump onto the moving vehicle. Now, Barnes's mother sued the officer on behalf of her son, and she argued that the officer violated her son's Fourth Amendment rights against excessive force. Now, on review, the district court granted a motion for summary judgment in favor of the officer, applying what was then the Fifth Circuit's moment of threat rule. The Court of Appeals on review in the Fifth Circuit affirmed that explaining that the moment of threat rule requires asking only whether an officer was in danger at the moment of the threat that resulted in his use of deadly force, and under the rule, events leading up to the shooting are not relevant and cannot be considered. Now, this case made its way all the way to the U.S. Supreme Court, and on review, the Supreme Court issued a 9-0 unanimous ruling in favor of Ashton Barnes and his mother. And in that ruling, they said that a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. The inquiry into reasonableness, they stated, of the officer and the force requires analyzing the totality of the circumstances. That analysis demands careful attention to the facts and circumstances relating to the incident. So in this case, the Supreme Court rejected the more limited moment of threat analysis and moment of threat rule that was used in the Fifth Circuit, and instead they applied their totality of the circumstances and said that the Fifth Circuit should have also applied that type of analysis. Now, after the Supreme Court issued that ruling, the case was then sent back and remanded back down to the Fifth Circuit for a re-review in a new decision in light of what the Supreme Court just said. Now, interestingly, the panel in the Fifth Circuit did not hold or arguments in this case or ask for additional briefs in light of the new Supreme Court ruling. All they asked for was some kind of status updates, some supplemental, updates based on what the Supreme Court just said, but they did not request official briefs in this case. And they did not ever set any, oral argument. Instead, both sides simply asked for this case to either be re-reviewed fully by the Fifth Circuit or to at least send it back down to the district court for new evaluations and more, evidence and factual arguments based on what the Supreme Court just said. But instead of doing that, the panel there in the Fifth Circuit just ruled the case on their own, ruled on their own swante. In the new ruling, the panel held that even under the totality of the circumstances approach, the officer's actions were warranted. The panel reasoned that any vehicle flight creates a deadly threat, and that the officer reasonably believed and used lethal force to prevent that dangerous situation. Now, because of that quick new decision, without additional arguments or briefs, Barnes and his attorneys actually petitioned for the Fifth Circuit on panel to re-review this case and take the case en banc. The petition argued that this new ruling by the panel contradicts what the Supreme Court just said in their new unanimous ruling, and even, contradicted what Judge Higginbottom had earlier said in this case in a prior ruling, that if they had to use the totality of the circumstances approach, there is no way that they could rule in favor of the officer. However, suddenly on re-review after remand by the Supreme Court to apply that analysis, they still came to the same conclusion. Now, the petition urged for a rehearing en banc in the Fifth Circuit because they said, essentially there was this per se rule that was created by the three-judge panel where officers may shoot any fleeing driver even when only a minor stop is involved. It argued that this conflicts with Supreme Court cases and precedent, and even with long-standing precedent in the Fifth Circuit, that a fleeing vehicle does not automatically justify using deadly force. However, the Fifth Circuit on panel recently just issued their order and denied review to this case. In that notice and the denial there by the Fifth Circuit on panel, it stated that the petition for panel rehearing is denied as no member of the panel or judge in regular active service has requested that the court be pulled on rehearing en banc. The petition for rehearing en banc is denied, and as a result, the Fifth Circuit three-judge panel also just issued their official mandate in this case. That was issued on the 21st, and that officially closes this case out in the Fifth Circuit. So this is something we're going to have to now watch very closely, because now the three-judge panel has issued their order sui sponte after the Supreme Court remanded this case. A rehearing en banc was sought in the Fifth Circuit that was denied, and now the Fifth Circuit has issued their official mandate. It is surprising that the Fifth Circuit panel decided to issue a new decision on this case without requesting additional briefs or oral arguments in light of what the Supreme Court just said. They decided to do that sui sponte. And it's also surprising that the en banc panel denied review of this case, and no one in the Fifth Circuit wanted to re-review this based on what just happened. So where this leaves this case is this now teased this case up to go back to the Supreme Court just 6 months after the court issued their new 9-0 new unanimous ruling, applying the totality of the circumstances and remaining this case to the Fifth Circuit for a new ruling. It is likely that the petitioner will argue that the Fifth Circuit has failed to properly apply the new Supreme Court ruling, and they may go to the Supreme Court once again and ask for the Supreme Court to step in because the Fifth Circuit got this wrong and procedurally did not handle this case correctly. Now, whether or not the Supreme Court will decide to re-review this case just 6 months after is yet to be seen. But that is kind of the last avenue for the petitioner here to go to the Supreme Court once again and say, hey, you just issued your ruling 6 months ago. You said to apply the totality of the circumstances. The lower court, did this really quick procedurally. We don't think that they did this correct, and now you need to step in because you're kind of our last hope once again. So again, we're going to be keeping our eyes on this to see how this plays out. As we get more information, as this develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All those things help to fuel the algorithm. And also, you can check out one of these 2 videos here on the screen that the YouTube algorithm thinks that you will find helpful. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.